Dear Judge Fowle, private and confidential. It is highly telling that Jamie Shakeshaft has marked this communication private and confidential when it concerns an ongoing judicial process. Tribunal proceedings are bound by the principle of open justice, and any attempt to solicit private consideration from a judge without disclosure to the other party is a serious breach of procedural fairness. This raises the question, why the secrecy? It suggests an attempt to exert improper influence on the tribunal. Under the Employment Tribunal's Rules of Procedure 2013, Rule 92, all communications relevant to a case must normally be shared with all parties. Marking an email private does not override this obligation. The very fact that Mr. Shakeshaft thought he could communicate with the judge confidentially underscores his disregard for fairness and transparency. Further to the various correspondence on the above case, I feel compelled to bring to your attention the national press coverage of Miss Ashwell, the claimant. Newspapers that have commented are the Mail Online, the Sun, the Metro, the Daily Star, the Mirror, the Daily Mail, and others. Mr. Shakeshaft is using national press coverage to cast me in a negative light, despite the fact that the respondent and its associates, including Chris Robshaw and Camilla Kerslake, orchestrated that very coverage to intimidate and defame me. This is a classic tactic of reputational warfare. Create the scandal, then point to it as proof of unfitness. This behaviour potentially engages defamation law, Defamation Act 2013, and could also constitute witness intimidation under Section 51 of the Criminal Justice and Public Order Act 1994, since the press coverage was deliberately engineered to deter me from pursuing my claims. Newspapers have commented, Jamie Shakeshaft knows that while I'm not named in the articles, the coverage makes me easily identifiable to anyone familiar with the situation, including my professional and personal networks. This is precisely why, at the outset of proceedings, I requested privacy orders. Yet, Mr. Shakeshaft is not concerned with my reputation, only that of Mr. Robshaw. The respondent's actions, defaming me in the national press, having me unlawfully arrested, and now seeking to sway the tribunal, show a complete lack of respect for me as a victim. These facts support my claims of sex discrimination, bullying, constructive dismissal, and also criminal matters such as collusion, witness intimidation, harassment, and perverting the course of justice. Whilst Miss Ashwell is not named, there are a number of inquiries from press attempting to establish her name and to gain more information about our employee Chris Robshaw, a contestant on this new season's Strictly Come Dancing. And we, with respect to the tribunal, to Chris Robshaw and his reputation, we again ask that this matter should remain private. We are concerned still about Miss Ashwell's state of mind and her inability to maintain confidentiality. She has already stated that she is prepared to whistleblow the tribunal proceedings. The BBC have already taken action to remove videos that Lani published on her YouTube channel. Here, Mr. Shakeshaft attempts to stigmatise me and pathologise my behaviour. The only reason my mental health has suffered is because of repeated intimidation, harassment and collusion following my rape at a company event, which I believe was orchestrated by directors of Binex, including Mr. Shakeshaft. It is revealing that Mr. Shakeshaft and his associates are terrified of exposure. An innocent party would not be threatened by any supposed whistleblowing, only those with something to hide are. This is an attempt to manipulate the tribunal into viewing me as unstable, thereby undermining my credibility. This behaviour could amount to a breach of the Public Interest Disclosure Act 1998, which protects whistleblowers from retaliation, and a breach of the Equality Act 2010, which protects victims of sexual violence from being further victimised. The BBC have already taken action. This line is perhaps the most telling. Prior to Mr. Robshaw's approach to the BBC for Strictly Come Dancing, my YouTube content was shadow banned. I then received an influx of activity on my channel. From this email, it appears BBC producers or their associates may have mass-reported my videos to have them banned in the UK. If my evidence were without merit, there would be no reason to try to suppress it. The attempt to have it erased from public view is further proof of collusion and reputational protection, not of innocence. This directly engages issues of Article 10 of the Human Rights Act 1998, freedom of expression, and raises serious questions about media interference in judicial proceedings. Best, James. The informal best sign-off betrays an inappropriate familiarity in correspondence with a sitting judge. Combined with the private and confidential header, it suggests an atmosphere of undue access and chumminess, inconsistent with the impartiality required of judicial proceedings.